The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Good morning and welcome back to Condo Craze and HOAs. We are live in our studio here, and I am with attorney Eric Glazer. He's board certified in Community Association Law, and I'm Karen Curtis, the host. We've been doing this for what, 15 years, I think?
At least.
Yeah. Every Sunday at 11 a.m., taking your calls, your questions in the chat about anything that makes you crazy. And today we are talking about House Bill. Yep, this is a House bill that's going through the House right now into the floor, 657, and whether it could eliminate mandatory pre-suit mediation in HOA disputes. Eliminate mandatory pre-suit mediation in HOA disputes. So what is going on here?
All right, here's the problem. For decades, Florida required pre-suit mediation before certain HOA disputes could go straight to court. Why? Because homeowners were getting buried in attorney's fees. Let's say 20 years ago, somebody left their garbage cans out and the association would simply file suit. And suddenly that owner is exposed to prevailing party attorney's fees costing them $5,000, $10,000, $15,000 before they even blink. So how did the legislature try to correct this? In its wisdom, they stepped in and they created pre-suit mediation, and it worked. And now House Bill 657 proposes to do away with pre-suit mediation and instead force homeowners right into this new HOA court where one judge in the county will hear all the condo and HOA cases. Now, look, I don't just litigate these cases. Probably a lot of you who are even watching have even seen and sat down with me while I actually served as a mediator in your case, and I've been doing that for over 20 years. And I'm telling you, cases in pre-suit mediation, they settle routinely, they resolve, and homeowners, by going there first, avoid massive legal exposure by staying out of court. Now, when this bill was making its way through the House and it was in front of the Civil Justice and Claims Subcommittee, Representative Gottlieb correctly raised questions about, number one, where the judges are coming from for this new HOA court, and number two, the mediation portion of the bill. And ultimately, he voted against the bill. This guy gets it. Rob, why don't you play that clip?
Thank you, Madam Chair. I'm still confused about the bill. I've read it a couple times. There's some things that I'm concerned with. I understand that the legislature is providing the money for the Community Association Court program. I don't know where the judges are coming from. So if we're going to take them from other divisions, those are going to be down judges, or if we're providing new judges.
All right, I'm telling you, the docket in this new HOA court, it's going to be insane. The judge, you know what the judge is going to do? The judge is simply going to force every case where to mediation, because it's impossible for one judge to deal with all of these cases. Remember, right now, you have like 20 judges in Dade and Broward, right? And they're dividing all these condo and HOA cases. Representative Porras wants to put all these cases in front of one judge. And when asked about this at one of the meetings, that's exactly what he admitted to.
So Gottlieb is an attorney.
Yep.
Porras is a 28-year-old representing Miami-Dade County. He's been
not
in
an
office
attorney
since 2022, went to FIU,
right.
God bless him.
Right.
But yeah.
Suddenly he's an expert on how the court system works.
So what was his response?
Well, here's the bottom line. It's impossible for one judge to deal with all these cases. Removing mediation is only going to make affordability harder on homeowners. They're now going to have to face lawyers' fees, court fees, and mediation fees. And you want to know his response? Yeah. Rob, play his response.
On the issue of pre-suit mediation, I wanted to start there. Pre-suit mediation in the past, and some homeowners brought it up today, is hand-in-hand part of the issue with the affordability crisis in homeowner associations. If a person is not getting their documents, if there's not an election, if the HOA is not meeting statute, the HOA will fight back on the homeowner.
If
and
this
just for
guy
any attorney
thinks pre-suit mediation
and talk to a homeowner about what is supposed to be their right statutorily that we provide to them, they have to pay an attorney tens of thousands of dollars to go through the pre-suit mediation, which deals with bureaucrats up here in Tallahassee with DBPR, which prevents any sort of litigation from happening, which something that could have been solved by a judge in a matter of days.
Now, if this guy thinks going to pre-suit mediation costs tens of thousands of dollars, he has absolutely no concept of the very bill that he filed. None. It's going to court.
But he
that
used the
costs
key
tens
word.
of thousands of dollars.
He used affordability.
Affordability,
That's the
right?
word.
Yeah, that's the word. Well, going to court is what's unaffordable. That's where unaffordability comes in. Going to court costs tens of thousands of dollars, not going to pre-suit mediation, but that's where he wants us to start, in court. Let's say someone isn't getting their documents, right? There's a solution to that. That's exactly why pre-suit mediation was created, right?
Yeah. So, they can call our show, Crazy and HOAs,
exactly.
and ask about it, and you'll help them.
Hey, Rob, why don't you play the rest of that clip?
Governance completely has failed a majority of homeowners that live in these homeowner associations. The main issue here is obviously HOAs, HOA attorneys, HOA board members do not want this bill to happen because they know that people are going to fight back.
Representative Porras also went on to say that governance has completely failed a majority of homeowners. Really, Representative Porras, show us the data to support this. That's all we're asking for. If anybody benefits from removing mediation, it's not the homeowner. You know who it is? It's me. It's lawyers. So the idea that lawyers oppose this because it hurts them, that doesn't add up. It makes no sense whatsoever. Mediation means less litigation, which means fewer legal fees, not more. This bill protects lawyers. What a great bill for lawyers. This is going to buy my wife and kids more things. That's what this bill is going to do for me, quite frankly. But this question is simple. What problem are we solving? And I say this, the legislature created a solution for a problem that doesn't exist. That's the bottom line here.
And you're a mediator, so
Yep.
you do make some money on that, but it's not perfect.
No, mediation's
Is it
not perfect.
perfect?
Nothing's perfect. Of course not. But here's what people need to understand. The moment that a lawsuit is filed under Chapter 720 or 718, prevailing party attorney's fees are in play. Once litigation starts, the financial exposure to everybody, quite frankly, changes immediately. If you go to mediation before filing suit, no prevailing party attorney's fees. If you file, if you go to court first, now you've really escalated the risk. And here's the irony. You want to laugh about this one?
Oh, yeah.
The statute itself, right now, still says mediation reduces court dockets and offers a cost-effective alternative to litigation. Right? It's still going to say that if this bill passes.
So it
That's
says
the
cost
irony.
effective, and he's saying that the affordability is the problem.
Correct. I mean, and that language is still going to stay in there, even if 657 passes all the way and gets signed by the governor.
Well, but there's no companion bill in the Senate.
So far, none. That's correct.
All right.
So Representative Porras, he did respond publicly, and you want to know what happened there? Like I said, we tried speaking to him. He said once the bill was filed, he's happy to listen to feedback, but every attempt I made was silent. So we posed policy questions to him. For example, what data shows mediation is failing? We have data that shows it's working incredibly well.
Yeah.
How many cases would this new court division handle? Have judges been consulted about this? And get this, instead of answering the questions, we got insults. We got deflections.
Oh, this is my favorite. Ready?
Yeah, instead of an intelligent response. What did he say, Karen?
Quoting Representative Juan Carlos Porras, good luck with your failing podcast.
Nice, huh? Failing. Audience, they think the show's failing? Hundreds of thousands of views, and we're failing.
How many laws have you drafted? How many changes have you helped?
Many.
60 Minutes consulted you.
Right, exactly.
After
Thanks,
Surfside
Karen.
fell.
Thanks. But when asked to support his own bill with facts,
failing
he
pod.
came back with insults. Can you imagine a member of the House of Representatives speaking like that?
He's young. He's going to make mistakes.
Yeah, but I'm sorry. That shows a lack of intelligence, and that's certainly not somebody who deserves your vote. You know, look, our job is to educate. That's it. Really, that's what we've been doing here for 15 years.
How many people have you helped?
Right. Thousands of Floridians tune in weekly because Tallahassee affects their wallet. It's not about ego. It's certainly not about my ego. It's about financial risk for homeowners. That's it. We ask questions, we expect some answers.
Yeah, so what happens financially if mediation is removed as the first step?
So let's walk through what would happen if this bill goes through. A lawsuit gets filed immediately, right? Attorneys get retained right off the bat. Discovery begins. Motions get filed. Prevailing party attorney's fees are now in play. And the association funds its lawyer, as we know, through assessments. The owners are going to pay for that. And at the same time, simultaneously, that poor homeowner, they have to fund their own lawyer.
Right.
So they're paying for it twice.
So if you do mediation and you have discovery there, it can be used in trial.
Absolutely.
So that's a savings right there.
Well, if you go to mediation and you find out certain things, yes, those things could be taken with you to trial, absolutely. But if mediation happens before suit and the case settles, no prevailing party attorney's fees. And that's why the statute was created in the first place. It was a consumer protection measure, and making court the starting line instead of the last resort, it increases the financial risk for everyone, actually, except the attorneys.
So his argument is affordability, and it's completely wrong.
Completely the opposite.
And that's the only...
Completely the opposite. Remember, he came out of the bat and said that pre-suit mediation costs tens of thousands of dollars. In what world?
And that's his defense.
Right, correct. Hey, Representative Porras, if there's a compelling data that shows mediation is broken, show it. That's all we're asking. But replacing a cost control mechanism with a more expensive one, it requires an explanation. That's all we're asking for.
I mean, this is crazy. What is going on with this bill? So it's ready to go to the House floor.
Yes.
So, you know, it started off solving real problems. We had HOA termination in this bill, which we talked about, and we liked it. And we're trying to get him on the show to talk about that.
Yep.
And then now he's got this in it, and it doesn't make sense.
No, it doesn't make sense. This bill's going to hurt homeowners. But let's do this. We're going to take a break, and when we come back, let's talk about what will actually happen if this bill passes. I really need to make this clear if we didn't do it already. We'll then take your calls. We want to hear from you. Should we force litigation and rip out mandatory mediation from homeowners? Rob, I know you're running a poll, right?
Yep, let me see this.
Okay, submit your answer. Stick around. We'll be back right after this.
Paul thought being on the board meant volunteering.
We demand this pool open now!
Now he's somehow in charge of a construction project larger than anything he's ever owned.
Your top concrete layer of your pool deck all needs to be removed so we can waterproof the structural slab. It's all very simple stuff. You do understand all of this, right?
I understand.
He doesn't, but HCMC does. Save your weekends, sanity, and suntan. Let us manage the mess. Call us to discuss your project at 954-805-5235.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
And welcome back to our failing podcast, Condo Crazy.
Objection.
HOA, it's Karen Curtis, attorney Eric Glazer. We're talking about HB 657. This is Juan Carlos Porras' bill on how dangerous dangerous it is. Let's say HB 657 moves forward as written through the House. Does it actually look like a typical Florida? What does it look like for a typical
All right, let's say
homeowner?
a dispute happens, and maybe it's a records request, like I said. Instead of mediation first, a lawsuit gets filed, and now the clock starts running on attorney's fees. Lawyers are billing like crazy, believe me, and now prevailing party attorney's fees are triggered. And now the conversation changes from how do I get my records to, and I see this all the time, why the hell did I start this, and how the hell do I get out of it? And that's the shift here. And
Right.
That's when attorney's fees are in play.
Oh my God, yes. So supporters say mediation stalls cases. Is that true? I mean, what would you say to that? You're a mediator.
I don't see that at all. Mediation only stalls if people aren't negotiating in good faith. But here's what 30 years of doing this has taught me. Most cases settle when both parties sit down with a neutral mediator. Both parties understand the risk. Once litigation begins, everybody loses financially, like I said, except the lawyers. And if mediation starts, by the way, you can always go to court. Court is still there.
That's
but
right.
if you start in court, everybody's lost already, and that's the difference.
But everyone's going to not be happy in the end, and that's the point.
If you start out in court,
Mediation.
if you start out in court, you're coming up with God knows how much money right off the bat,
But
and that's
mediation-
going to make everybody unhappy.
But mediation, you should be pretty much, if it works, everyone should.
Everybody
not-
should be happy
Oh,
at
then
the end.
everyone
That's
should
it.
be-
When
okay.
yeah, then everybody should be happy. I always tell everybody, if I'm being truthful, I tell everybody this. At the end of the day, when I serve as a mediator, you're never going to get everything you want at mediation.
But that's
and
what
if both of you walk out feeling a little miserable today, I did my job.
Yeah, so you've mentioned judges before. What happens if this creates a special HOA court? Can the legislature even create
I don't
a
even
court
know if the
like Judge
legislature
Judy?
can create this. And that's what Representative Gottlieb said. He
He's
had
a lawyer.
real doubts about whether the legislature can actually do this, and this is actually the job of the Supreme Court. But judges manage a volume, right? If you flood a court division with HOA and condo disputes, what's the first thing that happens? The judge is going to refer the case to where? Mediation.
Oh, no, you're
But
kidding.
of course, but now a lawsuit's already been filed. So instead of mediating pre-suit, right, with no prevailing attorney's fee exposure, you're mediating after fees are already accumulating. Someone's already going to be on the hook for those
And
fees.
they can appeal it.
Appeal it if they lose.
Yeah.
Yes, absolutely. Could go on forever.
Oh, my God.
Right. That's not reform, and that's rearranging the process in a way that increases risk. It's terrible.
So what should homeowners be asking their legislators? And we're going to put Porris's information up on the screen. There's a QR code. You're asking us for his information, his email, his phone number, so you can call him. It's up on the screen.
Absolutely.
But what
Hey,
are we asking?
Ask your legislators this, right? 3 simple questions. What data do you have that show mediation is failing? I can tell you, not only is it not failing, it's working incredibly well, and it's helping to keep God knows how many cases out of the courtroom, right? Number 2, how many cases are expected under this new structure, right, to go in front of one judge? When asked at one of the hearings, do you think all these cases are going to go in front of one judge in the county? Is that your plan? His answer was, yes, that's my plan. That's an insane plan. How could one judge in the county handle all the condo and HOA cases? And the next question you want to ask is, how does removing pre-suit mediation reduce financial exposure to the owners? Again, he doesn't get the bill. He doesn't get what he filed. If he came out of the box and said that pre-suit mediation costs an owner tens of thousands of dollars, he does not understand what he filed. And those are fair questions. Again, it's not personal, it's policy, and policy has financial consequences.
I have a question. So
Yeah.
in condos, is there a similar situation where it goes
It's not
to
mandatory. You can if you want in certain cases. Typically in condos, you start out in arbitration sometimes.
Okay, which
the
is not
arbitrator
binding.
can send you to mediation,
Okay.
right? And you could start out in court. And the court, let me tell you something. If you told me right now condo cases have to start in mediation, let's do it.
Okay.
Absolutely. Unfortunately, that's not the case for condo cases. Should it be? Absolutely. It should be for both, quite
Oh,
frankly.
so maybe he's trying to make it homogenous.
Yes, but why do it homogenous in the wrong way? Make it homogenous in the right way.
Right, the
Send
other way.
both cases to send condo and HOA cases to mediation first, not the court. Let me tell you something, what I've learned after 35 years. The courtroom is only a place for rich people. Believe me when I tell you, how many people can afford to pay lawyers $500 an hour generally?
No,
How
no.
many people can afford that?
No
The
one.
last place you want to be is a courtroom. The absolute worst place to be is a courtroom, right? Starting out at the mediation table, a fantastic benefit for homeowners and condo owners throughout the state. That's where we should be.
It's like a plea deal.
It's
You need a plea deal.
yeah, a way to get out
Yeah,
of things without going to court. Exactly. Rob, what's the audience have to say?
Yeah.
Let's take our first call, actually.
All right, let's do it. So let's go to, it's like Debbie
Hey, Debbie.
or Daniel.
Debbie or Daniel, same thing. Who do we got?
You're live.
Hello.
Yeah, hey, good morning.
Good morning.
Danielle?
How can we help?
No, Joanne.
Okay, Joanne, close
That's
enough.
why I didn't answer it first.
How are you,
You got
Joanne?
the wrong names mixed up there.
Oh, we're
How
a
can we
family
help?
podcast.
Recently, a group of us from our HOA filed with DPR election
Right.
for a problem with the election.
Okay.
Combined, first of all, every attorney won at $10,000.
Okay, there you go. $10,000 right off the bat.
Oh,
Right. Okay.
Yeah. So, and it ended up costing like $25,000 for each side. The HOA lost, and our insurance had to pay both. So it was about $50,000.
$50,000 in
DDPR
attorney's fees.
arbitration.
God, I'm gonna be wealthy after this one.
Good
Let me
for
tell you, this is
you.
gonna be great.
good for you.
Yeah. Yeah, terrible. So, so let's say
So
this was an election
that's
dispute.
the stories that are coming out. And while I completely understand your concerns,
So
I'm
let's say,
seeing
hold
the
on,
other
let me-
side of it. That
Debbie,
whenever
Debbie, no,
anybody
no.
wants to file, and
Hold on,
actually,
hold
they
on.
were told
How do we cut her off?
that they could not represent.
Hold on, Deb. I don't know if she hears us, doesn't hear. I don't know what's going on. But she's saying that she was forced into litigating this actually in arbitration, right? And she's complaining about the bill. So my question to her is, what would have been the problem if you would have started out that dispute at the mediation table, and perhaps it would have resolved there? Now, I will tell you, in the cases that I mediate, no question me saying this, 80% of the cases are
Really?
resolved at the mediation.
80%?
No question about it in my mind. 80% of the cases are resolved at mediation. So what would have been the harm if these types of cases, like an election dispute, whatever, start out at the mediation table and stay out of the courtroom, stay out of arbitration if possible? If it can be resolved, everybody saves money. She just said that the insurance company or the association wound up paying $50,000 out for their attorney, to 25 to one attorney, 25 to another attorney. What do you think is going to happen to the insurance bill of that association now going forward, now that they have a claim where their insurance
Does
company
ins-
paid out $50,000?
So the insurance covers these types of things?
Yeah, if you go to court, you turn it over to your insurance company. If you go to arbitration, you turn it over to your insurance company. And what do you think is going to happen now that the insurance company paid out a $50,000 claim?
It's going up.
Their insurance premiums are going to go way up.
My other
Okay?
question is just to make sure, if how can this also have a companion bill in the Senate, because there isn't one right now?
There isn't one right now, and I'm hoping that there isn't going to be one. And
then
we
it's
will,
dead.
get in touch with the powers that be in the Senate.
Yeah, Senator
And-
Albritton is the president, so we'll
And
talk to him.
we will be doing our homework. I
He's
promise
Mr.
you.
Measure 3 times, cut once.
And I'm hoping that the fans of this show also do their homework. Who else we got, Rob?
Should we go back to the caller?
Yeah.
No, good. Next call. They're backed up.
If this bill passes, can I be your partner, Eric?
I love it.
Here you go. Out over to Dan in Boca Raton.
Hey, Dan.
Hi, Eric. This is Dan. I am a fellow attorney of yours, actually. You and I know each other well.
Great.
And I very strongly agree with everything you are saying as a fellow practitioner.
Thank
In
you so
fact,
much.
When you just recited the 80% number, I told my son, who's here listening,
Yes.
right before you said that 80% of
There
the
you go.
cases that we bring
There you
to
go.
pre-suit mediation settle there.
Dan,
And I am...
and I know who you are well, my friend. Absolutely. And I just don't get it. Why in the world would you rip out this statute, force people into a courtroom when there's no proof whatsoever that mediation is failing. There's no proof. There's zero proof.
All proof to the contrary. Actually.
Exactly.
It's very
Exactly. Dan, I so appreciate it, and I so hope that you, everybody that you can possibly get in touch with, you contact your legislators, people on the show contact your legislators. I'm telling you, this is going to hurt our clients, and it's going to hurt our clients big time. It's going to
I wholeheartedly agree, and I just wanted to call and tell you I listen to your show, and I appreciate what you do for our condo HOA community. And you are spot on with this. This is when I read this, I was shocked.
Dan, I can't tell you how much I appreciate a call like that from a fellow attorney. Thank you very much. Really appreciate it. It means a lot.
You guys have a good weekend.
Thank you so much. That was a great call. Who else we got, Rob?
All right, over to the next one. Leslie in Palm Beach.
Leslie, good morning.
Hi, Eric. Hi, Karen.
Hey, good morning.
So what's going to be if this goes through? Nobody's going to buy into the units because there'll be litigation in the condo.
Well, this isn't for a condo. I want to be clear. This isn't forcing condo disputes into court. It's forcing HOA disputes into court. Okay? There was this bill, this pre-suit mediation bill, right now it only ever existed for HOAs. It forced HOA disputes into mediation, not condo disputes, okay? So that's this bill attempts to take away the ability to start your HOA case in mediation. Condos will still be the same.
I have a question, though.
Yep.
In the state, there's more HOAs than condos,
Yes.
even though we have a lot of
That's
condos
right,
in
Karen.
South Florida.
This is going to affect more HOA owners than there are condo
In fact,
owners.
there's like
That's
one
exactly
person
right.
in the legislature that owns a condo.
That's exactly right.
They all are
That's
HOA.
Exactly right. But this is a really bad bill. If you live in an HOA, you should be terrified, basically, to ever do anything wrong in your HOA, like leave your garbage cans out. Because
then you're
let
going
me
to
tell
court.
you, I want everybody to realize this.
God.
What incentive there is now for a lawyer who represents an HOA, right, to see somebody made this little violation, whatever it may be, bang, file suit. File suit right away. Why? I just made 10 grand. Just by filing suit, I made 10 grand. And that poor unit owner is going to pay for it. There's such incentive right now, if that bill goes through, to be aggressive. And Representative Porras says pre-suit mediation costs $10,000? No, now you're going to cost owners tens of thousands of dollars or more if your bill goes through. That I could promise you. Attorneys will be chomping at the bit to file cases against owners, believe me. Rob, who else we got?
All right, let's go to...
And if the owners have to pay, no one else does. It's just you. It's on you.
That's correct. It's on you. That's exactly right.
Whoa.
Who else we got, Rob?
Okay, it's hard to make out the name in the transcription, but if you heard a beep, you're alive.
Mamie?
Hello?
Yes, good morning.
Barney.
Hi, how are you today?
Okay, good morning. How can we help?
Good. I love your program.
Thank you so
I have a
much.
question
Appreciate
for
it.
you. Unrelated, but kind of related, actually.
Yes.
HB 683 was signed by the Florida governor, which allows residents to install artificial turf lots smaller than an acre. With this bill, it can be installed in the front yard. Now, before, it was only where it could not be seen. Before the final bill was signed, the DEP had to make a ruling which would govern the type and installation of turf. The law is finalized, and it's going to be, I believe, the middle of March, and it will become law. I asked my HOA if they will allow the turf, and they said no.
Oh.
When I told them there's nothing in our documents that prohibit it, they just ignored it and said, it's too bad. They're just not going to allow it. The town that I live in has said they will follow state law. So I asked the DEP if the HOA can deny me, and the DEP said no, they can't because it is state law, as long as it complies with state law and the DEP requirements. So how do I proceed to make sure I can install this turf?
Okay.
Mediation.
Well, we don't want it, therefore we won't allow it.
So now if she installs the turf, right, instead of that dispute starting out
Right.
in mediation, it would start out in a courtroom. And the minute that case is filed, she's facing attorney's fee exposure in the tens of thousands. Trust me.
And they don't have Kaufman in HOAs.
There you go. Now that you just raised something that's crucial, and that may be why her HOA is fighting against her.
Right.
Let's say there's a provision in your governing documents that say that owners are not allowed to install artificial turf, right? Let's just say that that's
she said it isn't,
in your documents. Oh, I didn't hear her say that.
Yeah, she said her documents say
oh,
no.
There is nothing in the documents that prohibit any type of artificial turf. In fact, it says nothing about type of turf.
Then if the law
Nothing.
passes, I can't see how they could prevent you from installing it. Where I was going with that, and I know this isn't the case in your community, but where I was going with that is, let's say a community's documents prohibit it, which a lot do, believe me, right? Then a board or an architectural review committee would say, we're not going to listen to this new law. Why? Because it changes our contract in a significant way. It changes the appearance of the community. We don't have Kaufman language. We don't have as amended from time to time language, and therefore we're not going to allow that new law in our association. And would the HOA win? Probably. If they can show that it changes the community in a substantial way, a substantive way, they win, and they wouldn't have to listen to the new law. Now, I understand in your case there is nothing in the documents that allow the board or the architectural review committee to prevent it. So it seems to me they'd probably have to listen to the new law. And now, if you want to fight it, you better do it before July 1st, because when 657 passes on July 1st, you're going to be forced into court, and attorney's fees are going to be in play. So I suggest you file the pre-suit mediation requirements that are currently in 720.311 well before July 1st, so you wind up saving a lot of money. Okay?
Yeah, I'm going to go ahead, and I'm getting everything together showing the DEP ruling. The whole thing was predicated on the fact that turf is not permeable, but that has been disproven. It is permeable.
Okay.
One of the problems that we have in our community is that we are on such severe water restrictions.
Right.
We cannot keep our lawns.
I understand, and that's why these laws were created. But to tell you the truth, I'm no expert on it, but I do know this: we got to take our bottom of the hour break.
Does she mean DEB? Does she mean DBPR? No. What is DEB? Or what do you?
Which?
What?
I think the environmental protection or something along those lines. Could
DEP.
Could
Very
be
good.
that. Okay, let's take our bottom of the hour break. Taking your calls, 917-452-9378, or drop us a question or comment in the chat box on YouTube. Back right after this.
Not per.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
So welcome back to the second half hour of Condo Craze and HOAs, and we're talking about HB 657, which would eliminate mandatory pre-suit mediation in HOAs. And you guys are commenting because this representative, Juan Carlos Porras, 28 years old, he represents Miami-Dade, doesn't know what he's talking about. He says it would help affordability, but it does the opposite. And you guys are saying
Anybody who could stand in front of the Florida legislature
And
and
say
says that pre-suit mediation cost a homeowner tens of thousands of dollars
the opposite.
has no idea what they're talking about. That's the bottom
and
line.
you tried to reach him, and he said, no, just
Come
go back
on,
to your...
Rob invited him on the show.
should
Come
go-
on, let's go. Come on the show. Let's talk about it. The floor will be yours. You can talk to all of our listeners, no problem. It will not be a fight of any kind. It will be respectful. Let's just
We
talk
just want to
about
hear
it.
the facts.
That's
we just
all.
want
Let's
the
just
truth.
talk about it. No
so
problem.
Tim says, please don't pay any attention to this knucklehead. We love your podcast, because he said, go back to your failing podcast, Boris.
Yes.
Someone wants to, they want to know if Boris is an attorney. He's not.
He's not,
an
no.
attorney.
But apparently knows everything about the court system at 28.
Yeah.
You know?
If this law isn't optional, many homeowners will be harassed and left to accept their doom by a board. Is that true?
They will be doomed
Or
by the attorney.
by
I
the
know
attorney.
that. That I can tell you.
If living in a hut under a bridge is beginning to seem like a better idea, can the association, let's see, we have 12 deeded boats live. Oh, we talked about this last time. Yeah, they can, because if they are deeded, if the association are given to the condo, then they can sell them. That was the last time.
I don't know the question. I'm not sure what the question was. If they're deeded,
Yeah.
then it's the owners, and that's the end of it. The condo can't touch the slips once they're
Mediation
deeded.
is a good thing, pre-eliminating weak cases.
Mediation is a great thing. If somebody's case is weak, I can tell you that as a mediator, when I break the parties out, you know, maybe some people don't know what mediation is, but let me just tell you how it starts. It starts off where, and it's amazing, we used to do this at the table, right? Now it's all done by Zoom, by the way.
Yeah.
But we get the parties on Zoom. Everybody starts out and all together, right? The plaintiff, let's say, whoever is the petitioner, makes their opening statement first. The other side gets to hear it. Then the other side gets to make their opening statement. I explain the mediation process, and I break the parties out into separate rooms, and I go back and forth until I try to get the parties to resolve the case. It gets put down on a piece of paper, the parties sign it, and it's an enforceable agreement in a court of law if you need to enforce it, right?
How much does that cost?
The parties are paying, let's say, $2,000 on average, splitting $2,000 on average.
Okay. So you're talking $1,000
right
each.
now. Let's say the case,
And it's binding.
and yes, if a settlement is reached, it's binding. Now, so that what did the owner pay so far? $1,000 for their attorney, something like that, and a little bit for the mediator, maybe $1,500. You want to go crazy? Let's say $2,000 that it cost them. Okay. If the case started out in court, right? First of all, if they need to hire the attorney, you just heard the prior caller says no attorney is going to touch me unless I have a $10,000 retainer.
That's right.
Right? That's number one. Number two, if that homeowner loses, right, they got to pay their attorney and they got to pay the association's attorney. There's how much at stake? $40,000, $50,000, $60,000, $70,000 at stake for that homeowner. Is it worth it to even risk asking for records if that can happen to you? Maybe, God forbid, I wind up losing a case. You have no idea how many times that an owner starts out with good intentions, right? They wind up, you know, in a lawsuit, and then the fear is, oh my God, if I lose, I now have to pay the other side attorney's fees. How much is it up to already? $30,000? How the hell did I get myself into this mess? It happens every single day. Every single day that a homeowner finds themselves in this situation, okay? Over simple things that happen with their home. And that's what's going to happen again if this bill goes through the legislature, is signed by the governor, and pre-suit mediation is removed. It's a disaster. Rob, who do we got?
Joe in Jensen Beach.
Hey, Joe.
Yes, good morning.
Good morning.
Thank you, Eric and Kathy, for taking my call.
Sure thing, Kathy. How can we help?
Okay, our condo elections are in March. One board member that was running just dropped out. Ballots were already mailed and votes received. Does this affect the election?
Well, because everybody sent back the votes already, you know, the only thing you can do is you're going to count the votes, right? Just like it was, you know, regular election day, like nobody dropped out. And if that person wins, right, if they wind up with a seat, you're just going to drop to the next person down on the list, the person who got the next highest set of votes. That's the only thing you can do, right? If they dropped out of the race after the ballots were mailed to everybody and they don't want to serve, then obviously you can't force them to serve. So the only thing you can do is take that next person that's on the list.
Just like Biden with Kamala Harris.
So basically,
They
right.
just put her in there.
Right. Yeah, you just go down that list, and you take the next person.
Don't worry about it.
Okay?
Listen, one more thing. You'll never fail in the public's eye. Keep up the good work.
Hey,
Don't let that get you all upset.
Nah, thank you so much. I really appreciate that. Boy, we got nice comments for a failing show today, huh? Really, really nice. I appreciate it, everybody. Thank you so much. And there's really nice things that are coming on the chat as well.
Yeah.
Much appreciated. You know, me, Karen, and Rob, we come here every weekend, I promise, just to help, just to answer questions. And it's an honor to do so. I don't think anybody comes here on a Sunday actually even feeling like you're going to work.
No.
No.
We love it.
We love, Rob, I don't want to speak for you, but if there's anybody that has a passion for the show as well, boy, it's Rob, let me tell you. Rob, you kind of worked hard to put today's show together, didn't you?
Just a little bit.
Yeah.
Just a little
Rob
bit.
has been...
Those videos were great. Thank
Yeah,
you. Back to
unbelievable.
the phones. Back to the phones.
All right, let's go to Joanne in Brevard County.
Hey, Joanne.
Yes, good morning, Eric, and I love your failing show.
Thank you. Thank you. Appreciate it. How can we help?
Okay. My question is, we had our annual meeting on February 11th, and I was elected, and we had the organizational meeting and selected officers.
Right.
Then on February 26th, 2 weeks later, I get an email from the management company that they found an email ballot that did not make it into the ballot box to get to the meeting. But it was dated on 2/6, so it had arrived before the meeting, but just was not counted.
Right.
So now the management company did a recount, and it shows that myself and another unit owner are now tied. So the management company the next day sends out an email to all the owners that a runoff election is scheduled for March 12th. I found 3 relevant DBPR arbitration decisions that have held that condo and HOA associations may not conduct election recounts after the annual meeting concludes
I am with you.
unless the procedure is set forth in the governing documents. Our governing documents / bylaws do not specify recount procedure. Can they legally hold this runoff election?
No. And why is the management company or manager making these decisions anyway? Do you have an attorney for the association?
We do. Apparently, they did not consult the attorney before they did the recount and the runoff.
So what your manager did, quite frankly, is risk their license.
Ooh.
Your manager should absolutely not be instructing the association on what the law provides here, okay? The person whose vote, the person who finished just underneath you, if they wanted to challenge the election, they could do that. There's a procedure for them to challenge it, obviously through arbitration. But once that election is done on election day, that's it. It's over. I agree with you, unless there is some procedure in your bylaws that would allow for it. And the bottom line is that should be an opinion that you get from the association's attorney, not from the association's management company. It's not their fight. The bottom line is they screwed up perhaps. Maybe the ballot, the email ballot was emailed to them. Is that what happened here?
It was emailed to, the manager. That's where all the email ballots went.
So they screwed up. They screwed up and they want to somehow, protect themselves now and, yell do-over, but that's not how it works. The person who lost or finished underneath you, they would have a right if they wanted to challenge what happened here in arbitration, but that's it. It's over. That whatever happened on election day, that's what happened. I mean, suppose they found a vote 6 months from now. Do we again do over? So there's a cutoff. What happens on election day, that ends it. That's the bottom line. Everything ends on election day. If they want to, again, fight it, file an arbitration case. I agree with you 100%. Get an opinion from association's counsel, not the manager. Tell the manager to butt out.
Okay, so can I go now and send them a letter stating this about the arbitration decisions and ask them to cancel the runoff election?
100% you should do that. Absolutely. But you should be letting the attorney for the association know what's going on.
Yeah.
Don't just communicate
yes, I
with
figured they'll send my letter to the attorney probably.
Well, no, how about, why don't you send the letter to the attorney?
And let them
Make
know
sure
you
they
did.
get it. Yeah, I mean, I'm not going to count on the manager to send it to the attorney. You should send it to the attorney. Okay?
Oh, okay.
All right.
Did
I wish you
copy
luck.
them in?
Yeah, let them know.
Let them know. Absolutely. What are you waiting for? You're on the board, right?
Yes, I'm on the board.
Let the attorney know what's going on. You have every right to, okay?
And let them know that you let him know.
All right. Thank you.
All right,
Wait,
thank you very much.
Thank you. So Theodore, he's nice like a dog with a bone. The HOA boards that it's the HOA boards that authorize lawsuits, not lawyers. The lawyers work at the whim at the boards. That's not.
Yes, but what do you think the HOA's attorney is going to do when they're asked, hey, do you think we should file suit on this matter? You know, what are your thoughts about
that's only if the board, it's on their side. But if I'm a homeowner, I'm going to file suit.
If you're a homeowner, right, now you really, really, really have to think about filing suit.
But I don't have the board deciding for me.
Of course not, because you're the homeowner.
So it's only if it's on the board side that would the suit be filed.
If it's on the board's side, right?
Right.
Then the person is making the suggestion that it's not the attorney that gets to decide whether the lawsuit is filed. It's up to the board, and I get that. But what happens is you have a meeting with the attorney. The board has a meeting with the attorney to say, hey, counselor, what do you think we should do here? Should we file suit? Well, no, now he's not going to say mediate anymore.
He can't
now
even do
he
it.
or she is going to say, well, the bottom line is attorney's fees are now in play. If we file suit, if you think you're right, nothing to lose. File away. Let's go after that poor unit owner. And the minute that we file, they're on the hook for all your attorney's fees.
You're gonna
what do you
say,
think the lawyer's going to say?
You're in the right. Go for it.
Go for it.
Yeah.
Absolutely. You have nothing to lose.
Yeah.
Yes. Make that poor unit owner pay $10,000 right off the bat.
You will win this. Go ahead.
That's what's going to happen right off the bat. And I'm telling you guys that's what attorneys are going to be suggesting, right? That you got nothing to lose now. Attorney's fees are in play. Go file suit. Litigation is going to be encouraged, not discouraged. Let's take our final break of the hour. Taking your call, 717-452-9378. Don't wait for the last second. Back right after this.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
And welcome back to our final segment of Condo Craze and HOAs. Don't wait to the end to call in. We're talking about HB 657, whether it should eliminate mandatory pre-suit mediation in HOA disputes. So if that's your question, we'll take it. We have someone already on the phone that has a similar question, or no?
You know what? Before we go to the phones, Rob, you started a poll.
Oh, yeah. Right? How's our poll doing?
Before, as the show started. What do you think about House Bill 657? Should we get rid of pre-suit mediation? What's the result so far?
So far, 94% said do not get rid of mandatory mediation.
94%. So it's close.
Yeah.
We're winning by a razor. Razor thin margin.
The 6% is Porous and his family.
Good one. Good one. All right. How about we go to the phones?
All right. Let's go to Lisa in Pensacola.
Oh, Pensacola.
Hey, Lisa.
Prettiest beaches in the world.
Lisa, how can we help?
Thank you. I was wondering about the part of the House bill that could, if you chose to dissolve the HOA, if that happens, how would the common areas be handled if you
Oh, that's a good
That's
question.
a great question. So
Like a golf course.
This is another thing that's quite frankly a little frightening right now. This HOA termination clause or provisions that are in House Bill 57 are being touted by Representative Porras as a way where if you don't like what your board is doing, just dissolve the HOA. Right? Then we'll have a dissolute. That's not what you want to do. That's crazy, right? You don't dissolve the HOA and say no more HOA because you don't like what your board is doing. If you don't like what your board is doing, vote your board out. Recall them. Because if you're going to terminate your HOA, now you have significant problems to deal with, like our caller is suggesting. What do you do now with the pool? What do you do with the roads, the clubhouse,
the golf course?
The golf course. What do you do with all these things? How are they going to be maintained? You know, you think your board is a bunch of bullies, so you wind up terminating the HOA? That if that's how this bill is being touted, and it is, that makes absolutely no sense. I'm telling you, listen to what I'm saying. He does not know his own bill. I'm telling you, because if you can suggest to the legislature that this is designed to take away, and I saw it, abuse by boards. If you're going to use this bill as a means to dissolve your HOA because you don't like the abuse that your board is doing, this is a terrible bill for you. Terrible.
Right now, you've got everybody paying for the golf course, everybody paying for the clubhouse.
So if you don't like your board, you don't like your board, so you say, okay, no more HOA. That's not what you do. There's a recall statute that's there for that very reason. There are elections there for that very reason. You don't dissolve the HOA. That's throwing the baby out with the bathwater. That's insanity. Okay, so great phone call. If you go down that termination process, ultimately it's going to have to go through a judge. A judge is going to want to see how you're in fact paying for your roads, right? People still need to drive down those roads to get to their homes, right? People still need the lights on in the community, right? Who's going to be paying for that?
Who's going to be
paying for security? Who's going to be paying for the gate, right? All of that still has to go through a judge. It has to be a plan of termination. By the way, what do you think the cost is to have an attorney do all this for you?
Oh, forget it.
Okay, so this bill being touted as, hey, if you don't like your abuse that your board is causing you, just go through the termination process. That is exactly what you don't want to do. You go through the termination process like condos are doing because a developer approaches the community and says, we want to buy everybody out, okay? So we want to be able to terminate the condo.
Okay. That makes sense.
Right. So that you don't terminate the condo because you don't like your board. That's the worst thing that you could possibly do. You don't like your board, again, vote them out. That's what elections are for, and that's what recalls are for. Okay, back to the phones, Rob.
All right, let's go to Rob.
Hey, Rob.
Hey, good morning. Steve, I just want to say I met you at the Tampa show a few weeks ago, and I took your class, and it was awesome. So
thank you so much. Appreciate it.
My question
You did
is,
call
we
me
have an
Steve, right?
upcoming.
I think he's Steve. Are you Steve?
I'm Rob.
Oh, okay. I'm Steve. Never mind. All right, go ahead.
To Rob.
Yes.
My question is about special/closed door meetings.
Yes.
And minutes. We have an upcoming meeting in a few days, and my question is, are minutes to be taken? I would assume they're not to be distributed.
Right.
It's a personnel issue.
I don't have a problem, and the statute doesn't address this, but I don't have a problem if minutes are taken. I think that there should be, for example, let's say the board discusses with their attorney whether or not suit should be filed against a particular unit owner, right? I think that should probably be documented somewhere in minutes, but just like you said, and you hit the nail on the head, those minutes should not be seen by the unit owners until the litigation itself is resolved, because until then it becomes, in my opinion, attorney-client privilege material. But yes, minutes should be taken.
This is not about a resident. It's personnel. It's our staff, our condominium staff. So a personnal matter.
Yeah, personnel matter. Gotcha. Now, as long as hold on one second. As long as it's about as long as you raise the issue of personnel matters, I just want to teach our listeners what personnel matters mean, right? So you're allowed to have closed door meetings when it comes to personnel matters. But what is personnel matters? And there's an arbitration case out there that personnel means people that are on the association's payroll as employees. In other words, you're withholding federal taxes from them. You're withholding Social Security from them, right? Those are considered employees. If you're not doing that, they're not employees. For example, your attorney, you're not withholding taxes from the attorney. Therefore, it's not personnel matter. Your management company, you're not withholding taxes from their pay.
Okay.
Therefore, it's not a personnel matter if you want to have a meeting about them. You understand that?
Yes, but this is definitely a personnel matter because
Okay,
it's an
gotcha.
employee who is working for us. Yes.
Gotcha. Okay.
All right.
Very good.
So you recommend we can take meetings?
Yeah,
but
I
not
think
to
you
dispute,
should, but
is that correct?
yeah, just make sure that nobody gets to see them. Keep them
Yeah.
closed. Yes. Okay.
So,
Great. Appreciate that, Steve. Thanks
Sure
for all
thing.
you do.
Yeah,
Call me Steve again.
So
Go
look,
ahead.
at logic basis is not Steve and Kathy.
Steve and Kathy.
And the other
Regis and Kathy.
Thank you, Eric,
Yes,
for all
thank
you
you.
do.
You
Thank
got
you.
it. Be
And
well.
the other 6% they're saying on the poll is lawyers.
Right. Exactly. Who are going to clean up. All right, let's take one more row.
Let's go to Joanne in Palm Beach County.
Hey, Joanne.
Good morning. Can you hear me?
Oh, very loud and clear. How can we help?
Thank you. First of all, I wanted to tell you from my personal experience, your classes are out of the park.
I lost
They are
She
outstanding.
loves your class.
And I
that's
really,
great.
really
Thank you
wish
so
there
much.
was more
Can you believe it? As soon as
mandatory.
you started saying that,
um,
I went out here for some reason.
And I wish there was more
Can't hear 'em.
mandatory effects that
wishes
you
more
could
mandatory.
get other people that are in the industry to take them because it would really help in many, many ways.
Thank
but
you.
here's my question.
Yeah, you're going to have to repeat.
I live in a condo with 186 units, and our condo is 55 years old, and it's in Palm Beach County. We have had an amenity which they call the exercise room. When I purchased, there was some gym equipment and
All right, what's
everything
the
in a
question?
small room, and that.
Get to the question.
Pardon me?
What's your
Oh.
question?
My question, well, I'm getting to my question. My question is the new board that came in and the manager wants to eliminate its location and put it in a unit that was used years ago for a maintenance person's residence, paying rent.
We gotta
and
go. I don't know
this
what
is
the
the
question
only
is.
place we could move the gym is in this facility. It's vacant now. It's been vacant for 4 years. They have not taken any revenue on it or anything. And they just think they can arbitrarily make that change. What is the process for that to the owner's rights?
I didn't hear the question. It's
Okay,
my-
so 186
question
units in a
is a comment-
condo is 55 years old in Palm Beach County. The exercise room, they want to move it. How do they go about
that
doing
would
it?
be considered a material alteration, right? If it's in a condo, that's a material alteration to the common elements. In order to do that, you have to look at what the governing documents say. And typically the governing documents say that in order to make a material alteration, you would need 75% of the owners to
And there you
agree
go.
in
You
that.
can't just move it.
And the statute says, right, and the statute says that if the documents are silent on the issue, you need 75% of the owners to vote in favor of that material alteration anyway. And if they make the material alteration, I had a case that went up to the 3rd District Court of Appeal on this one. If you make the material alteration before getting the vote, you may have to put it back, right? So, for example, a material alteration is like to paint the color of the building differently than what it is. And if you don't get that 75% vote, you're painting it back. You're paying for a paint job twice.
So, by the way, someone's asking, is mediation as binding as a court declaratory
Yes,
judgment?
exactly. Mediation is binding. You get the parties to agree to a settlement. It's put down on a piece of paper. Both parties sign it, and it is enforceable in a court of law.
Boom.
It's a great thing. All right. On that note, that brings us to the end of the show. I wish I was more motivated today,
I
a
wonder
little
if,
more into it.
Representative Porce will join us next week on our
Hey,
failing
open
podcast.
open invite. You're welcome anytime to discuss this bill, all right? I would love to, okay? We'll be kind, we'll be nice. We just want to debate it with you, that's all right? On that note, if you need legal help off the air, give Glazer and Sachs a call, 954-983-1112. Again, 954-983-1112. I know, Rob, you put up earlier the ways that they can contact Representative Porras or contact your local legislator. Certainly contact your local senator, local Senate, because we want to make sure that this bill does not get through the Senate. Contact them, please. Make sure you want HB 657 to die on the vine, as they say.
And share
okay?
this show if you're,
absolutely.
Please
okay?
go ahead, ring the bell, subscribe, and share the show.
For those of you who made nice comments today, and even if you didn't make a nice comment, the fact that you tuned in means the world to us. So again, thank you so much. And again, we love being here every week. It is always an honor and a pleasure. Okay, and on that note, everybody, we'll see you again next Sunday at 11 a.m. on Condo Craze and HOAs. Have a wonderful, safe week, you and your families. Be well.
Thank you.
Thank you, Madam Chair. I'm still confused about the bill. I've read it a couple times. There's some things that I'm concerned with. I understand that the legislature is providing the money for the Community Association Court program. I don't know where the judges are coming from. So if we're going to take them from other divisions, those are going to be down judges. Or if we're providing new judges, I think we may be overstepping our bound.
Same truth, same time, no smoke, no spin. See you next Sunday at 11 a.m. You've been watching Condo Craze and HOAs. Lights coming down, another hour gone. Hard truths, lines clearly drawn. Process matters, rules come first. Ignore them once, and things get worse. Read the rules, show up in form. When mistakes happen, don't take it personal. That's how lawsuits fade instead of grow. That's how communities stay in control. We take the calls, we hear it all. Helping Floridians stand tall. Condos, HOs, every voice has a place. When you face it head on, chaos loses the race. Same truth, same time, no smoke, no spin. See you next Sunday at 11 a.m. You've been watching Condo Craze and HOA.